In many communities, one can reasonably expect that somebody knows who committed which crime. I cannot say that with the same confidence today. In my view, crime intelligence deteriorated significantly during the period associated with former National Commissioner Jackie Salebi, and I believe that this deterioration was not accidental. I further believe that successive leadership structures within the SAPS have in some instances been compromised, suspended, or incompetent, therefore serving political interests rather than the interests of effective law enforcement. Crime intelligence funds became, in my view, another slush fund or source of patronage and employment for friends and family, particularly during the period associated with Richard Ndluli, the former head of crime intelligence. The anti-gang unit in the Western Cape was allocated a budget of 7 million rand to fight gangsterism, whereas crime intelligence has a budget of 600 million rand. Commissioners, if one wishes to destroy a country's law enforcement capability, one only needs to destroy its ability to detect crime. This was evident during the unrest and looting in 2021, when crime intelligence, in my view, failed this country. This was also reflected by various reports concerning KwaZulu-Natal, which was headed at the time by Brigadier Kumalo, the current head of crime intelligence. Commissioners, I have paid a heavy personal price for my outspokenness and activism. The toll on my family has been immense, and the emotional trauma experienced by my children has affected their social and their school lives. My mother is elderly and sickly and had to witness some of the events, particularly my arrest. My salary and my privileges as a member of parliament have on occasions been withdrawn, affecting my responsibilities towards my family. I have regularly been threatened with arrest, even before appearing before this commission. I was warned that I would be arrested after my appearance. And to be frank, Commissioners, if that indeed is true, I don't care. My most recent arrest was, in my view, not merely intended to embarrass me, but also to silence me. I regarded it as a final warning to shut up and to know my place. But, Commissioners, I can assure you that every time a mother, a child, a sister, or aunt dies in my community, I will attempt to be their voice.
Then, Mr. Adams, the next topic, history of my interaction with the various matters discussed at the Madlanga Commission.
Thank you,
Page
Advocate.
7.
Thank you, Commissioners. This statement is not intended to constitute political commentary, argument, or submissions on the ultimate issues that the Commission is required to determine. Those determinations fall exclusively within the Commission's mandate. My purpose is to place before this Commission the factual basis for my knowledge, my actions, oversight bodies, law enforcement agencies, and oversight bodies. Some of those complaints concern matters that overlap with the work of this Commission. Others provide necessary context to explain how I came to possess certain information, why I engaged with particular officials and institutions, and why I subsequently became involved in matters concerning the political task team, the PKTT, crime intelligence, and related investigations. I recognize that many of the matters referred to in the statement remain the subject of ongoing investigations or pending legal proceedings. Nothing in the statement should be understood as expressing a concluded finding or criminal or civil liability against any individual. Where I refer to allegations, complaints, or investigations, I do so because they form part of the factual chronology of evidence relevant to my evidence. I identify the status of those matters wherever I am able to do so. Where reference is made to annexures, those annexures are intended to corroborate or contextualize the facts set out in the statement. They include correspondence, official records, complaints, court documents, transcripts, recordings, and other contemporaneous material generated before or during the events described herein. Before addressing the factual matters that form the subject of this evidence, I consider it important to explain the approach I have adopted in presenting my evidence. Over a number of years, I have been an activist, a community leader, elected public representative, and a member of parliament. In those capacities, I have frequently spoken publicly on matters of corruption, organized crime, policing, governance, and public accountability. Those engagements have necessarily involved political debate, public advocacy, and expression of opinions concerning the matters of public importance. I appreciate that my role before this Commission is fundamentally different. I appear before the Commission as a witness, not as an advocate, commentator, or politician. I fully recognize that the Commission's function is to make findings based upon reliable evidence rather than rhetoric, opinion, or political persuasion. I have therefore sought to present my evidence in a manner that assists the Commission in discharging its mandate. Throughout the statement, I have endeavored to distinguish carefully between the facts that I personally witnessed, the actions that I took, the information communicated to me by identifiable individuals, which I identify as such, and opinions or concerns that are held relevant at the time where those opinions are necessary to explain my conduct or my actions. I do not ask the Commission to accept any allegation merely because I've made it. Where documentary or other corroborating evidence exists, I have identified. Where investigations remain pending, I have attempted to indicate the fact. Where I rely upon information obtained by others, I identify the source wherever I am able to do so. I also recognize that some of the matters referred to in the statement are or have been the subject of criminal investigations, civil litigation, or other processes. Where I express concerns, suspicions, or inferences, I do so because they explain why I've acted as I did, why I referred matters to the relevant authorities. I respectfully leave the determination of the facts and the drawing of ultimate conclusions to this Commission. I understand that my evidence, like that of every witness, must withstand scrutiny. I welcome that scrutiny. It is in that spirit and with due regard to the solemnity of these proceedings that I place the following evidence before this Commission.
Then the next topic is on page 15, but I propose that we not go through this topic. It's a duplication of what you deal with on page 18 onwards. So it's really a summary of the allegations. It's called Nature of Complaints Made Over the Years, and then you deal with it in detail from page 18. I would suggest that you just read paragraph 125 on page 18 into the record.
Thank you, Advocate, Commissioners. I respectfully submit there is not any single complaint that is significant. Rather, it is the cumulative pattern of interactions within state institutions, the responses that were provided to me, the investigations that followed, and the events that ultimately culminated in my own interactions with the PKTT, crime intelligence, and the matters now before this investigation. Before this Commission, excuse me.
Then the next topic, engagement with law enforcement agencies and oversight institutions.
Thank you, Advocate. Thank you, Commissioners. Throughout my public life, I've consistently adopted the view that allegations of criminal misconduct, corruption, or abuse of public office should be reported to the institutions established by law to investigate such matters. I have therefore sought wherever reasonably possible to utilize official reporting mechanisms rather than attempting to investigate or determine such matters myself. In the ordinary course of my work as a community activist councillor and later a member of parliament, I engaged with numerous law enforcement and oversight institutions. Those engagements arose from complaints made by members of the public, information that came into my possession, matters uncovered during oversight work, and documentary material that appeared to disclose possible criminal or unlawful conduct. On many occasions in the Parliamentary Committee, I sought to hold SAP's management accountable for various issues. The records of Parliament will reflect those engagements. For the purposes of this statement, and having regard to the limited time available to me, I will concentrate on issues that have subsequently come to the attention of the Commission. It has been deeply frustrated because, in my experience, the Portfolio Committee on which I serve sometimes fails to hold the SAP's management adequately accountable and instead permitted SAP's management to obfuscate, avoid questions, or rely upon standard answers such as "we cannot answer the question because it is under investigation," "we cannot answer the question because of security-related matters." On a previous occasion, I asked the National Commissioner how many members of his family worked in his office and whether those persons had gone through the proper appointed process. On the 18th of September 2024, I asked the National Commissioner General Fani Masimola to explain why Lieutenant General Dumisani Kumalo had been permitted to purchase a redundant cell phone grabber. No satisfactory response was provided. Please see Annexure FAA1. Page 8. In my view, the National Commissioner was permitted to avoid accounting to the Portfolio Committee concerning this matter. However, Brigadier Tiani Shlongweni has subsequently articulated reasons why, in his view, public funds have been wasted. This does not excuse what I believe to be a failure to account to the Portfolio Committee. Just for noting purposes, our Commissioners, Brigadier Tiani Shlongweni was the CFO for the crime intelligence, what is called the slush fund. On 12 March 2025, I asked the National Commissioner about the top-level security clearances of senior SAPS officials. This included the issue of Lieutenant General Kumalo, whose first security clearance was allegedly fraudulently obtained. Please see Annexure FAA2. On 19th February 2025, I asked the National Commissioner to please provide to the Portfolio Committee the names of generals, including provincial heads, who lacked appropriate security clearance. Despite the National Commissioner's assurance that the information would be provided to the committee, to my knowledge, it never was. Please see Annexure FAA3. At the same meeting, on 19 February 2025, I asked the National Commissioner about the lack of media attention concerning case number 1/11/2024 relating to an incident in which more than 100 million rands worth of mandrax was allegedly found and no media statement was issued. Please see Annexure FAA3. General Abia responded that the clandestine laboratory was under investigation. The last known status of this case reflected firearms and made no mention of drugs. If I may just expand on this issue just a little bit, and why I took this kind of personally. In KZN, on 19 February 2025, a Cape Town-based drug team uncovered a laboratory in KZN. They confiscated 100 million rands worth of drugs, mandrax. Now, in my view, the South African Police Services needs all the positive publicity it can get. This should have been a cause for celebration. They never reported it to the media, and certain people are saying that they were told not to speak about it. When I asked this question, I was told it was under investigation. The current status of that docket now, right now, speaks of firearms, no mention of drugs. Why I take this personally, Commissioners? It is a known fact that mandrax, it was the tablet that was used to enslave the Cape Flats. To this day, I would say 80% of mandrax sold in this country is sold right there where I live. Those drugs disappeared to be sold to our children. That is why I took that personally. I've also raised the issue of property purchase in Musgrave, KwaZulu-Natal. My concern was that crime intelligence did not have a mandate to procure properties outside the prescribed process, and that, to my knowledge, there had been no deviation or approval. I further raised concerns that the property price appeared to be significantly inflated. On 15 September 2025, I emailed the Inspector General, IGI, concerning the matter. A complaint had been lodged, and the IGI subsequently confirmed to me that he had completed his investigation and the final report had been provided to the Minister of Police. Please see Annexure FAA4. I requested of the IGI as a copy of the report. The IGI, I think I was stupid with that, but anyway, the IGI informed me that it was not possible or lawful to provide such a copy to me. I accepted that. I subsequently contacted Minister Mkhunu, but did not receive a response. At that stage, I became concerned that there might be a cover-up of this report. Please say Annexure FAA5. Depending upon the nature of the complaint, I referred matters to SAPS, specialized investigative units within SAPS, the Hawks, the NPA, IPID, the IGI, parliamentary committees, and other competent oversight bodies. My purpose in referring these matters is never to determine guilt or innocence. Rather, it is to ensure that allegations which appeared to disclose possible criminality or serious administration were investigated by the authorities entrusted by law with those responsibilities. Excuse me. In many instances, my involvement concluded once a complaint had been submitted together with the documentation that was available to me. In other matters, I was requested to provide further information, clarify aspects of the complaint, produce documents, identify witnesses, or cooperate with investigators. Commissioners, in some cases, I'm unable to receive the further information. For instance, the source may say to me, I'll get you that, and then he's unable to. Or the source may turn around and say, please don't mention my name. So in some cases, I do lay charges, and unfortunately nothing is able to happen. My level of involvement, therefore, vary depending upon the nature of complaint and the responsibility of the investigation. Others were referred between institutions. Some complaints are investigated promptly. Others were referred between institutions, and some appeared to progress slowly or not at all. I do not suggest that every delay or outcome was improper. I merely record my observations because they form part of the factual background against which the matters now before this commission have developed. As the number of complaints increased over time, I observed that certain investigations begin to overlap. Matters involving organized crime, firearms, procurement irregularities, intelligence structures, and policing increasingly involve recurring institutions, officials, or investigative structures. It was through these recurring interactions that I became aware of issues relating to crime intelligence, the PKTT, and allegations of interference with criminal investigations. I wish to make it clear that I did not ask the Commission to infer wrongdoing merely because I lodged complaints or because investigations are initiated. The existence of a complaint is not proof that it is true. My evidence concerns the fact that complaints were made, the information upon which they are based, the responses I received from the relevant institutions, and the events that follows. In several instances, I retained copies of correspondence, acknowledgements of receipt, emails, affidavits, recordings, and other contemporaneous documents generated during my engagement with the relevant authorities. Some of those documents have been preserved, were available, and annexed to this statement, or will be made available to the Commission as we have it. They provide an objective record of many of the interactions described in the chapters that will follow. I again apologize for documents that I may have omitted. Such omissions were not deliberate, but have resulted from circumstances sometimes beyond my control. My engagement with these institutions was not confined to reporting complaints. In my capacity as a Member of Parliament, I also exercised parliamentary oversight by posing questions, participating in committee proceedings, scrutinizing reports, and engaging directly with senior officials concerning matters falling within their respective mandates, including in terms of Section 55.2 and 56 of the Constitution. These engagements frequently provide additional context for complaints that have already been referred through formal law enforcement channels. As a source of further information, I also conducted parliamentary oversight visits in accordance with the National Assembly Rule 201.6, where I received complaints regarding further investigation or oversight. In the chapters that follow, I deal with each of the principal engagements separately, identifying the chronology of events, the institutions involved, the documents relied upon, the responses received, and where applicable, the significance of those events to the Commission's term of reference.
Then, still on page 23, the next topic, complaints concerning crime intelligence. There are some complaints that are historic that don't really relate to the issues that you were asked to address. So at some point, I'm going to ask you to skip some paragraphs. But you can start with 169.
With respect, Advocate, if I may ask on this paragraph, if I may be allowed to read everything into the record.
Okay.
Thank you very much. My concerns concerning crime intelligence. Crime intelligence is at the heart of the fight against crime. And this is, in my view, the pulse of policing in relation to crime prevention and detection. A malfunctioning crime intelligence unit has extremely far-reaching consequences for the fight against crime, as is evident from the current situation. South Africa, particularly since 2000, has been used for various purposes, including political battles, patronage, and the maladministration of slush funds. I believe this was perfected during the period associated with Richard Mdluli. In my view, crime intelligence operated on a nepotistic basis involving jobs for friends and family, and at times functioned more like a glorified employment agency. I have attached an example of nepotism in Annexure F8826. Numerous reports have previously been commissioned concerning crime intelligence and its weaknesses, but in my view, insufficient action was taken to eradicate the problems that have developed. Crime intelligence, in my view, requires a complete overhaul, together with a structured approach to the execution of its mandate. Unfortunately, it appears to me that Lieutenant General Khumalo has followed in the footsteps of his former leadership within crime intelligence. This chapter deals with my interactions with and concerns relating to crime intelligence and the associated intelligence structures within the subs. The matters described herein do not arise from a single event. Rather, they develop progressively over a period of time through complaints received by me, documentation that came into my possession, my engagement with oversight institutions, and my interactions with members of law enforcement. My interest in matters relating to crime intelligence arose in the course of performing my duties as a councillor and later as a Member of Parliament. During that period, I increasingly encountered allegations suggesting that intelligence structures were becoming relevant to complaints involving organized crime, policing, political interference, and the administration of criminal investigations. I regard crime intelligence as having been a festering open wound that has continued to attract undesirable and in some cases criminal activities since approximately the year 2000, although similar problems may have existed to a lesser extent even before then. In my view, successive heads of crime intelligence were selected in circumstances that gave rise to concerns regarding political influence and accountability. During this period, the crime intelligence budget also increased disproportionately compared with other internal policing units and divisions. In my view, crime intelligence was not always utilized primarily for intelligence gathering, but at times was used for personal gratification, patronage, and employment of friends and associates. At the outset, I did not possess sufficient information to determine whether all of these allegations were well-founded. My approach was therefore not to make public findings or conclusions, but to seek further information, preserve relevant documentation, and refer matters to the authorities responsible for investigating them. As additional information became available, I observed recurring references to officials within crime intelligence, the administration of intelligence resources, security clearances, intelligence oversight, and the interaction between intelligence structures and criminal investigations. It was these recurring themes, rather than any preconceived belief, that caused me to examine the matters more closely. Where I received documentary material that appeared to disclose possible irregularities, I sought to preserve that material in its original form and, where appropriate, refer it to the competent authorities. Where information was communicated to me by third parties, I attempted, wherever possible, to identify the source of that information and distinguish between verified facts, allegations requiring investigation, and matters that could not be independently confirmed. During the course of my parliamentary duties, I also engaged with senior officials and oversight institutions concerning matters relating to policing and intelligence. Those engagements, together with official correspondence and responses received from the relevant institutions, assisted me in understanding the statutory framework governing intelligence structures and the mechanisms established to ensure their accountability. Certain concerns that I raised were subsequently referred to or considered by oversight institutions, including the IGA, the IGI, and other competent authorities. I do not suggest that the existence of such referrals establish the correctness of these allegations. I refer to them because they demonstrate that these matters were considered sufficiently serious to warrant investigation by institutions responsible for intelligence oversight. As my engagement with these matters continues, they increasingly intersected with issues concerning the PKTT, allegations of political interference in policing, the appointment and deployment of senior officials, security clearances processes, and the integrity of investigations falling within the Commission's terms of reference. The purpose of this chapter is not to invite the Commission to draw conclusions concerning crime intelligence as an institution or any individual official. Rather, it is to explain how my interactions with intelligence-related matters developed, the steps that I took to report my concerns through official channels, and the factual background against which the subsequent events described in this statement occurred. In the chapters that follow, I deal individually with the principal matters that inform my concerns regarding crime intelligence, including the information that came into my possession, the referrals that I made, the responses that I received, and the extent to which these matters are relevant to this Commission's inquiry. Where I express concerns or draw inferences, I identify the factual material upon which those concerns were based and distinguish them from matters falling within my direct or my personal knowledge. I respectfully emphasize that this Commission is not being asked to accept my concerns at face value. My evidence is directed at establishing the chronology of events, the information available to me, and the relevant times. The steps that I took in response to that information and the documentary record that supports those actions. The ultimate findings in relation to crime intelligence is its officials or any related institution remain matters exclusively for this Commission.
The next one is complaints concerning the political killings task team, and I'm sure you're going to tell me you want to read all of this as well.
I thought we agreed to play nice this morning, our advocate.
I am, believe me.
My complaints regarding the political killings task team. My engagement with matters concerning the PKTT did not arise from any personal animosity towards its members or any political disagreement concerning its continued existence. My concern was the financial support the unit investigating a few dozen murders was receiving. There's just a correction that needs to be made here. The PKTT has a 100 million rand a year budget that does not include overtime.
So not 1 million?
Not 1 million, that's my mistake. This happened in haste, please excuse me. So the PKTT has a 100 million rand a year budget that does not include overtime. It is actively investigating 130 murder dockets over the last 36 months. This translates into a total spend of about 2.3 million rand per murder docket. In contrast, the AGU that operates in my community in that same period would have been combating approximately 8,000 murders on the Cape Flats, of which the majority of them are colored children. The Cape Flats is an area that is roughly 10% the size of KZN. In comparison to the PKTT, the AGU receives 2,600 rand per murder docket. It makes no sense. I was also under the impression that when the President announced the establishment of the unit, it would have had an end date because the mandate of a task team in general is specific, and that this unit, the PKTT, was not intended to become one of the more permanent structures of the SAPS. I therefore became concerned when I subsequently learned that the PKT was operating in the Western Cape, the Eastern Cape, Gauteng,